How long do police and prosecutors have before bringing a criminal charge against you after a crime has been committed in the state of New Hampshire? The answer depends on the time periods described in what is New Hampshire's statute of limitations, as well as the nature and type of the underlying offense. But the basic public policy idea is this: if too much time passes from the time of an alleged criminal incident, evidence could be lost or destroyed, documents could go missing, important witnesses could have naturally their memories fade, and we want people to be able to responsibly move on in life and law, unfettered by the threat that the other shoe could drop and a criminal charge could issue against them. So we require, therefore, police and prosecutors to act within a statutorily prescribed period of time that depends on the nature of offense. For minor offenses like non-criminal violations, police and prosecutors have to move quickly. They only have 90 days to act within New Hampshire statute of limitations. For minor criminal offenses, which are described as misdemeanors, which are crimes, but less serious crimes and felonies are, they still have to act reasonably quickly within 1 year from the time the event took place. For felonies, which are more serious criminal offenses, generally speaking, police and prosecutors have 6 years from the time an event occurred in order to initiate a charge against the potential wrongdoer. That's the basic set of statutes that describe how quickly police and prosecutors must act, but there's also several important exceptions. The most intriguing one is for murder, where police and prosecutors have the entire lifetime of the potential suspect in order to potentially initiate a homicide charge against them. Serious sexual assaults involving children also have an important extended limitations period, or 22 years after the victim's 18th birthday, in order to initiate a charge, which is until the alleged victim turns 40 years old. And that's because when a sexual event involves a child, the fear is that young person doesn't have the wherewithal, the network, or the intestinal fortitude to come forward and initiate a complaint in real time. So after adulthood, we want to afford a fair amount of time to allow him or her to do so. And also, events involving children don't often occur in the open. They occur behind closed doors so that there's few witnesses often to come forward, which is why the statute of limitations is extended in that example. There's other exceptions too. Should a wrongdoer commit a crime and then leave the state, very often under New Hampshire statute of limitations, the limitation period tolls or delays, giving police and prosecutors more time to act in that example too. If a crime is committed by a person who is in public service, you've got 2 years from the time that that person leaves their post in order to potentially initiate a prosecution against them. For crimes that involve a breach of a fiduciary duty, police and prosecutors have 1 year from the time that they've discovered the crime. The same concept applies as well to events that involve the falsification of evidence, where police have 1 year from the time that they discover the event in order to bring a charge against that person. New Hampshire statute of limitations also describes other nuances and exceptions as well, but those are the big ones. If there's a criminal charge initiated against you, but there's been some delay and you wish for a qualified criminal defense lawyer to evaluate that delay and whether or not the statute of limitation bars your prosecution, give us a call. My name is Jim Rosenberg. I'm a lawyer and a partner at the firm of Shaheen & Gordon. We've got offices throughout the state of New Hampshire and in Maine as well.